May it please the Court, my name is Masters, initial T, and I represent Mr. Marshall Ike in this matter. My client pleads not guilty to the charges, and under 590AA of the Queensland Criminal Code, we submit that evidence gathered by the Crown is inadmissible. Under Section 130 of the Evidence Act, the defence submits that the interviews and admissions of guilt be excluded from evidence at trial. As in the cases of Lee and Christie, we submit that on the evidence provided, Your Honour should choose to exercise your discretion to exclude this evidence, as it is more prejudicial than probative. On the facts, the officers showed a disregard, either by choice or lack of knowledge, of cultural competency. When my client Mr. Ike was being questioned in the back of the police vehicle, neither officer identified that the information elicited was simply gratuitous concurrence. It has been identified that Australian and Torres Strait Islanders, henceforth referred to as ATSI individuals, will commonly answer in the affirmative when there is a power imbalance, especially when questioned by persons of authority, as a sign of respect, even when this may not actually reflect the truth. Furthermore, my client was identified to have been consistently looking at the floor and answering in very short answers. In Lee, it was identified that this was a common occurrence when ATSI individuals were displaying gratuitous concurrence. We submit that the egregious actions of the officers constitutes a breach of their responsibility as set out in Lee. Under Section 420 of the Police Powers and Responsibilities Act, henceforth referred to as the PPRA, police must allow a suspect to speak to a support person of their choosing. On the facts, my client was not afforded these rights. Mr. Ike was not allowed to speak to a qualified support person of his choosing, and the police supplied a support person who advised my client that he must answer the officer's questions. During questioning of an ATSI suspect, it is required under Section 420 of the PPRA that police must notify legal aid that Mr. Ike was in custody, unless they believe that the suspect is not at a disadvantage. On the facts, there is no evidence that the police would believe Mr. Ike not be at a disadvantage. In fact, there is clear evidence to the contrary, being my client's age and his general demeanour clearly signalling gratuitous concurrence throughout the arrest and questioning process. The defence moves that the evidence gathered under these circumstances was not in accordance with the police officer's legal obligations. We seek that Your Honour uses your power under the Section 590AA of the Queensland Criminal Code to exclude this evidence under public policy discretion. In Lee, it is confirmed that if police wish to interview a juvenile suspect, of which my client Mr. Ike is, there must be a parent or guardian present. If this right is not afforded, the evidence will be considered too prejudicial and will not be allowed to be submitted into evidence. On the facts, it is clear that my client did not have the rights enforced, and due to the precedent set in Lee, and thus under Lee discretion, the defence moves that this evidence should be excluded. Section 436, subsection 4 of the PPRA states that evidence gained through police questioning must be recorded, which, on the facts, the evidence procured in the back of the police vehicle was not, and should be excluded from evidence. Section 437 of the PPRA outlines that a written confession must be obtained, and on the facts, this was not supplied by Mr. Ike to the police officers. On all the aforementioned evidence, the defence submits that the Crown should not be able to use this evidence obtained against the Lee discretion guidelines and the PPRA. We believe it is clear that the evidence gained is substantially prejudicial, and that when considering the inaudibility of the recording and lack of written confession, that the probative value is not very helpful in establishing the facts claimed. Therefore, we ask that Your Honour excludes this evidence from the trial. The defence also submits that the evidence should be excluded under Bunning discretion. Due to the improper and illegal actions of the police officers, in Bunning, 5 factors must be considered to determine whether evidence should be inadmissible. The first factor to be considered is whether the conduct resulted from a genuine mistake or a deliberate breach of law. On the facts, it is unclear whether the officers in question chose to disregard the steps for proper questioning set out in the PPRA, or whether it was a genuine mistake that they supplied insufficient support. If the Crown can sufficiently argue that the actions were a genuine mistake on the part of the officers, then Factor 2 will be considered. The second factor regards cogency of the evidence. On the facts, it is obvious that the officers have disregarded proper procedure when collecting the evidence during the interview, as many parts of the recording are inaudible, which could have been easily circumvented, and there is nothing to show that the evidence gathered was of perishable nature. The third factor asks if the conduct was a genuine response to a pressing circumstance. On the facts, it is evident that there were no pressing circumstances. Firstly, the nature of the crimes would arguably never produce that of a pressing circumstance. However, if the court disagreed, we believe that it is blatantly obvious that if the officers had time to drive Mr. Ike around to 84 properties before moving to a situation in which they could record any evidence, then it is indeed not of a pressing nature. In regards to the fourth factor, which assesses the gravity of the charges against Mr. Ike, my client's accused crimes on their own are not overly serious crimes. It is only in combination that they may be considered more serious, and again, we believe the only evidence that suggests any of these crimes should be inadmissible. The last factor to consider is whether the conduct of the officers breached a statute. The PPR is in place to ensure that police do not abuse their powers and ignore the rights of at-risk subsections of the community. As aforementioned, sections 420, 436 and 437 have all been breached by the arresting officers by not allowing my client to choose his support person and not properly recording evidence or obtaining a written admission of guilt. We believe that when comparing and contrasting the Bunning discretion factors to the facts of this case, that it is clear that the evidence was obtained under improper and illegal actions of the arresting officers. We therefore submit that Your Honour excludes all evidence from the case at trial and that the Crown should drop all charges against Mr. Ike. The defence thanks Your Honour for your time and consideration, and this completes our submission.